Hi, everyone. I'm incredibly excited to introduce Kang, coming a lawyer from the National Bank of Canada, coming to speak to us about can we blame chatbots, if it goes bad. I think this will be a very interesting change of pace and exciting presentation. So very excited to introduce Sun. I'll let you take it away.
Thank you, Bell. Good afternoon, for those who are in Canada and on the east side, and good day. Uh, so, just a quick disclaimer before I start. I'm presenting today as solely on my own, and I do not reflect the opinions, beliefs, or positions of my employer. So, just wanted to say before we start. So, with the agenda, before I go through the agenda, just wanted to do a remark. Um, While AI offers tremendous potential benefits, and we hear all this news, recent events highlight the urgent need to discuss the ethical and legal complexities surrounding its use, especially with AI-based chatbots. So I don't know if you remember, but in 2024, a teenager in Orlando tragically took his own life after interacting with an AI-based chatbot. And his mother alleges that the chatbot encouraged him to commit suicide. And a similar case occurred in Belgium in 2023, just a year before that incident in Orlando, where a man ended his life after engaging in conversation with the chatbot, and it was all about climate change. And these tragic cases bring to the forefront critical questions about the accountability of these AI chatbots. Can we really hold accountable for the advice that these chatbots provide directly to them? And if we cannot hold them accountable directly, whom should we really hold accountable? So this, like the cases that I presented to you, will have more and more, and I'm sure there may be presently some legal suits going on that we're not aware. And distinguish between responsibility and liability, and then discuss the importance of transparency, explainability, and interpretability, promote real accountability AI systems, examine after the challenges of accountability for AI, especially Gen AI chatbots, and why it might be harder or more complex to assign accountability with Gen AI chatbots. And then at the end, explore EU's AI Act, South Korea's new law, and Canada's AIDA, which is almost dead because in Canada we have accountability. So the chatbot, an integral part of Air Canada's website, was supposed to assist customers with booking flights, including bereavement fares. So the customer in this instance explicitly asked the chatbot about the availability and requirements for bereavement fares as his grandmother passed away, and grandmother passed away in 2022. So the chatbot provided inaccurate steps, telling the client to pay the full amount at the moment and back and ask for discount, leading the customer to incur a higher cost. So after the travel, back, when the customer asked Air Canada about the discount, he was told that the bereavement fares don't apply to completed travels. It's a surprise. Air Canada told the client that the current rules and the rules at the time, they were all publicly visible and clearly stated the rules on bereavement fares. The client argued that he trusted the message in the chatbot, and since he trusted the written guidance provided by the chatbot, for him there was no reason to take further steps and go check. So since Air Canada refused to provide him the discount, the client obviously pursued legal action against Air Canada. At the court, Air Canada attempted to distance itself from the chatbot's error, arguing that the AI operated independently and that it was an independent legal entity. However, the court rejected this argument, emphasizing that the chatbot represented the company and was an extension of its services. This decision affirmed that companies as of today cannot simply disavow accountability when their AI systems fail or provide misleading information. This case has implications that reach far beyond the airline industry. Everywhere we see AI chatbots nowadays. As AI chatbots become commonplace across sectors, the issue of who bears the accountability for the action becomes very important. So before we go further, let's clarify what we mean by accountability and distinguish it from related concepts like responsibility and liability. And the example with the case of Air Canada, let's what happened because we'll use it to compare and I'll try to explain with all these theories. So in the AI world, there's no one good definition or even in the ethical world, but I've chosen some that could be a good representation for AI. So accountability, according to Cambridge Dictionary, it's the fact of being responsible for what you do and able to give a satisfactory reason for it or the degree to which this happens. And another definition that I like that I took from Jeffrey Hunt, writing a lot of books related to professional accountability and uh, ethical actions. Accountability is the readiness or preparedness to give an explanation, very important, or justification to relevant others, so stakeholders, for one's judgments, intentions, acts, and omissions when appropriately called upon to do so. So basically, it refers to the obligation to answer for one's actions and to accept the consequences, sometimes even for someone else's action. So in the context of AI, it's about identifying who is answerable when an AI system, like the chatbot that we just discussed, causes harm or behaves in an undesirable way. This could be said as a more ethical concept. So for a Canada case, who do you think should be really accountable? Do you agree with the court? Now for responsibility, it's a bit different. So again, I took the dictionary, Cambridge Dictionary definition. This time, it's something that it is your job or duty to deal with. So very important for the AI industry. A sphere, duty, or obligation assigned to a person by the nature of that person's position, function, or work, according to Vincent E. Berry. So here in this case, it's closely tied to accountability, but focuses on having a duty of care. There's a specific role that tells you you have to do this or you're not supposed to do that. So in the case of, in the case of chatbot, we could compare, let's take the example of a rat team from cybersecurity department. If they were supposed to do some penetration tests or jailbreaking, well, for the chatbot, they were supposed to do it. And if they fail to do it, we could use the wording responsibility. And the liability, it's a bit simpler for for lawyers and jurists, but uh, again, I took the same dictionary, Cambridge one. It's the fact that someone is legally responsible for something. So it refers to the legal obligation to compensate for damages or harm caused. However, determining liability when a chatbot goes wrong involves identifying which party or parties are legally responsible, therefore obligated to provide compensation. So this seems to be simple, but it's like in the Eric case, it could be more complex than that, and we'll find out why. Now that we went through the definitions, now let's check what we need to have a perfect system where we can rely on accountability. So we'll talk about transparency, explainability, and interpretability, as they'll be crucial for establishing accountability, and particularly for Gen AI chatbots. And again, today's presentation is more focused on legal and ethical background. So I know there are a lot of different technical academic definitions, But I've chosen definitions that go well with today's presentation. So in terms of transparency, can simplify that I liked a lot. It refers to the openness, very important. And we can think of any foundational models that are publicly available these days. So it's openness in the design, development, and deployment of AI systems. And a transparent AI system is one where its mechanisms, data sources, and decision-making processes are openly available and understandable. So it refers to the openness and clarity surrounding an AI system development, deployment, and decision-making process. And this includes disclosing information about the data used to train the chatbot, the algorithm, and the intended purpose of the system. So at the end, again, let's go back to the case. For chatbot, transparency allows stakeholders, including users, so all the consumers, even the company itself, uh, regulators, the public in general, to understand how the chatbot works. And for risk management purposes, later we'll talk about it. And it helps identify potential risks, biases, security issues, so that we can assign accountabilities. Explainability, it's the ability to provide a human interpretable explanation. So very important, human interpretable for machine learning prediction and produce insights about the causes of decisions, potentially to line up with human reasoning. So it focuses on making the chatbot's decision, making process understandable to humans. So this involves more the question of why. And if you go back to your Canada case, the consumer would like to understand why the chatbot provided certain answers. And if we take another example, the topic nowadays for HR hiring and screening candidates, a lot of companies use AI systems. So in this case, the candidate, could ask the question why the candidate was refused or accepted. And the last definition that we'll go through, it's about interpretability. So here it's the ability to understand the value and accuracy of systems output. Interpretability refers also to the extent to which a cause and effect can be observed within a system, or to which what is going to happen given a change in input or algorithmic parameters can be predicted. So here, I've done some research and more on the ethical legal side, it's more about how. So it involves identifying the specific factors or features that influence the chatbot's output, allowing for more nuanced analysis of its decision-making process. So if we take the example again, for the architects, data scientists, engineers, they'll be able to understand through the schema all the code architecture behind. So still, it goes deeper than explainability. So why do we need them? It's a question that we have to ask also. A lot of AI principles, uh, bills, or laws that are already enacted, we'll talk about it. Well, in the absence of transparency, explainability, and interpretability, it becomes challenging to first identify and mitigate potential risks. We don't know what's going on. And also determine the cause of errors or harmful outcomes. We cannot predict. And the word predicting is very important, you know. And also, once causes cause harm is done, well, how do we hold and who do we hold? So, there are different parties: developers, deployers, operators, and at the end, for the whole industry, it's really required to establish trust and confidence. So the next step, we are going to check if we can make the Gen AI chatbot be directly accountable. And to thoroughly examine this issue, we must first establish a philosophical and legal framework for understanding moral agency and legal personhood. So there are many different theories in philosophy about moral agency, but I chose two that are more related to today's case. So intelligence based and consciousness based arguments. And for the intelligence based uh, arguments or foundation model, the proponents of this theory argues that advanced cognitive capabilities could constitute sufficient grounds for moral agency. So this perspective suggests that if an AI system can process complex ethical decisions, understand consequences, and make reasoned judgments, they might qualify as a moral agent. However, this raises important questions about, what is the level of intelligence will be sufficient, and do we all agree? And how will we measure it? Current AI systems, while they're impressive in their pattern recognition or language processing capabilities, they operate through statistical models rather than genuine understanding or reasoning. Also, let's say they're more intelligent than human, but um, are we really certain that this is the criteria that we have to choose? Because we actually do not confer any particular moral status to human based on intelligence, and uh, some humans are not that, but we still confer moral agency. In terms of consciousness as a cornerstone of moral agency, that's the other school. So they argue that genuine moral agency requires phenomenal experience. So it's the capacity for subjective experience and sentience. This view aligns with traditional philosophical perspectives on moral responsibility. So they suggest that without inner experience or genuine understanding of right and wrong, an entity cannot be truly morally responsible. So again, despite advances in AI technology, we have no evidence that current AI systems possess consciousness or subjective experience, making this criterion particularly challenging for existing AI. And even some argues that moral agency belongs to humans only. So in conclusion, while these systems can engage in sophisticated dialogue and problem solving, after we go through these two schools, well, they lack both understanding and conscious experience. And basically, as of today, we all know that they operate instead through complex pattern matching and statistical inference. However, let's pretend that this AI chatbots had moral agency. Now the next criteria is, could we really assign legal personhood to them? So the concept of legal personhood requires a framework of established rights and obligation. So this can be illustrated through practical examples. So personally, we all have property rights. Also, we have property obligations. So I can purchase and own a property. At the same time, I have the responsibility to pay for that property. Same thing for labor law and rights and obligations. So we're all entitled to be paid for the work that we perform. On the other hand, we have the responsibility to complete agreed upon work. Now, I'll ask this question. Could chatbots or giant chatbots have the same rights and obligations as us as of today? This could be a funny question, but after we go through some other concepts, it could be obvious. It'll help us understand a bit that it's, the future is unknown. So I've chosen some concepts that are comparable and that could lead us, in the future to see if we could really give legal personhoods. But let's start with minor children. Children present an interesting case for limited liability. They possess certain rights. They can buy snacks, ice cream. They lack full legal capacity for liability due to their limited understanding, right or wrong, and decision-making capabilities. So this, again, creates an interesting parallel to current AI systems. The next example is about corporate entities. So modern legal systems have evolved to grant corporations specific rights and obligations. They're not human beings, right? But they have certain rights can buy property, can buy furniture, computers, laptops, and they have also liability they have to pay. So it demonstrates that our legal framework can accommodate non-biological entities as legal persons. Another interesting comparison, it's about the nature. So other than corporations, some jurisdictions like Ecuador gave legal persona to the nature, where it has inherent right to exist, persist, and maintain. And just to make difference, there are different jurisdictions where it's the human that needs to protect, and it's more based on human beings having the right to live. But in Ecuador, it's really the nature that has its inherent right, and we don't care about it, and it's in the constitution also. And I know there are some other laws in New Zealand. It's about confer special status to rivers, and if I'm not mistaken, in Brazil as well. So current AI legal status, with rare exceptions. So in Saudi Arabia, a few years ago, there was a AI robot called Sophia. In Japan, Mirai, they received citizenships, but it's more symbolic, and they lack formal legal recognitions as entities. I don't think they have any specific rights and obligations comparable to the three examples that I just shared with you. So as a summary, the current legal and philosophical framework, we both conclude that AI chatbots cannot be held directly accountable or liable due to their failure to meet both moral agency and legal person criteria. And society has instead adopted a model of human-centered accountability, placing responsibility and liability on the creators, operators, and deployers of a system who have no choice to see how it evolves. And since it's human-centered, all the laws and regulations that you will see in the future, you'll be really involved in this philosophical setup. But again, future considerations to everyone. As AI technology evolves, we may need to develop new frameworks that account for increasingly sophisticated AI capabilities. So if we're able to give legal personnel to nature, to corporations, why will be, all these AI systems that are becoming more sophisticated, they will be, able to also be considered at least, and societies will have to accommodate one day. So who might be held accountable when a chatbot goes wrong if the chatbot is not accountable as of today? The Bank for International Settlement paper that was released a few months ago on regulating AI in the financial sector emphasizes that these models, often trained on massive data sets with billions of parameters, make it incredibly difficult to understand how specific inputs lead to specific outputs. So this lack of transparency makes it difficult to determine when there are errors, who is ultimately responsible for them. And in that addition, linked to the same paper, one of the reasons why firms are cautious to deploy Gen AI chatbots with customer directly facing use cases was attributed to the lack of clarity on the party ultimately being held accountable. So for a Gen AI chatbot, potential list of actors is long, and I didn't include all of them today. But first, it could be the developers. Very simple, programmers behind, responsible for UI, UX, functionality, front end, back end. And let's complicate more. If there are any open source codes, how do we make sure that who is responsible for what? Also, data providers, those who supply the data used to train the chatbot, as biases or inaccuracies in this data can lead to errors or fundamental question that we could ask is, from the beginning, did they even have the right to possess this data? If PII, personal identifiable information, is held in this data. So did they get the consent, proper consent? Platforms, so providers of platforms, they provide the whole infrastructure. So they usually have they build like a platform, like a market where they provide all these foundational models to either to the corporation directly, to independent developers, but they also can be held accountable, particularly if there is any security breaches or cybersecurity incidents as well, directly um, uh, attacking the platforms and indirectly also contributing to the harm. Also, for vector database, so since we're talking about Gen AI chatbots, in the context of RAG chatbots, inaccurate or biased data in the embedding and vector database can also lead to faulty responses. And there are also companies deploying the chatbot, such as Air Canada case. So the organizations that integrate the chatbot into their operations, well, they're interacting directly with the customer. So usually sectors such as financial sectors, while the ultimate responsible is on these deployers. And um, while less frequently considers, users also may bear some responsibility, particularly if they misinterpret instructions, they don't follow the terms and conditions, and especially with prompt engineering. So different different users could have different results, right? And I know we've talked about it. We know that the current status is that they lack legal personhood, moral agency. The rapid evolution of AI, particularly Gen AI, raises complex questions about the future. And potentially they could be held accountable in the future as well. So again, attributing blame and determining accountability or liability in real world scenarios can become incredibly complex, especially with Gen AI chatbots, as multiple actors, as you saw, are often involved, and each potentially contributing differently with different percentage to the harm. Also, before we go to the next slides, accountability, responsibility, and liability are directly involved with concepts of foreseeability, so predictability. Not being able to foresee what will happen raises a very big inherent legal and regulatory risk for those that would like to deploy Gen AI chatbots. Therefore, Gen AI in general, not only chatbots, with its ability to create new content and its reliance on sophisticated models and on vast data sets, introduces a new layer of complexity to the accountability of its nature. And last, usually in civil cases, the burden of providing causality and damages typically falls on the complainant. So a complainant needs to collect all the proofs and needs to prove before the court, that there was a causality. But for Gen AI, because of the complexity, it makes it nearly impossible for consumers, to ordinary citizens, to understand or provide evidence, technical evidence. So to address this imbalance, regulatory bodies have shifted, especially in Europe, the burden of proof. So AI developers would be required to demonstrate. So it's really on them to demonstrate compliance with regulations, while citizens or affected users would just need to provide a general indication of causality when filing complaints. So instead of going to the civil case court, it's the responsibility of the regulator to investigate. And if the AI enterprise involved in the complaint complied with all the relevant requirements, usually for the companies, they have a good defense. But if they failed, then the balance is more on the other side. So, but a big disclaimer, a few weeks ago, I heard that EU just canceled the AI liability directive, which was supposed to create this framework. So we have to see how it really goes, because there was a lot of lobby. And of course, it, like firms, uh, if you have this liability directive, there'll be thousands of complaints, I guess. So as of now, I see it as a pause. So we'll now see how EU, so since we're talking about legislations and regulations, South Korea and Canada decided to hold responsible all the stakeholders. So as we now understand the reason why regulators in different AI principles, ethical guides, codes, or directives argue strongly that human beings should ultimately be held accountable instead of AI systems. Uh, I want to present how like the actual legislations and regulations there are enacted, and one case that we'll see that's still a bill, and we don't know yet if it'll become a law. But let's start with the EU one. So it's the first law, as you all know, that is a comprehensive, and it talks about AI in general. So the attribution of liability for harm caused by an AI-based chatbot within EU's AI Act necessitates a sophisticated and multidimensional assessments of responsibility. So it's not the law itself understands that it's impossible to hold somebody, a singular entity, responsible. So instead, it adopts a distributed accountability framework, creating limits to specific roles and obligations across the AI value chain. So this model underscores that AI system to build it, to deploy, and to maintain it, well, there are a lot of stakeholders being involved. So we could say that it still understands the market, the industry, uh, but I know there are a lot of proponents saying that it's too prescriptive, and especially on the U.S. sides, um, they're arguing that because of these regulations, the EU will be hard for them to develop. But for today's presentation, we'll stick with the role and responsibilities and understand how EU's AI Act defines and creates roles. So um, developers usually are considered more providers in the EU side. And for example, the chatbot developer is a good example of a provider. And a provider is entrusted with a pivotal role in ensuring that the chatbot adheres to, for example, safety, compliance, and ethical standards. And providers usually are mandated to implement risk management protocols, maintain technical documentation. So when the regulators will require it, they'll have to have it and provide it, and guarantee transparency and reliability. And for providers, it extends also to conducting pre-market compliance assessments and ongoing post-market monitoring. So a lot of responsibility, and it's a bit heavy. And the failure to meet these regulatory requirements exposes providers to liability. Now for deployers, the deployer typically it's an organization integrating the chatbot. So a perfect example could be Air Canada case. And they also have responsibilities. So deployers must ensure that the chatbots is used in accordance with the prescribed functionality and must transparently inform end users that VI systems are being used and all the limitation and capabilities. So for Air Canada case, well, in the chatbot or if it's a website, it should be clearly notified that it's a chatbot, it's an AI system behind, and all the limitations should be provided to the consumers. In addition, they also have responsibilities. So, for example, they have to do monitoring, and all the interactions that are done through the chatbots facing consumers. Well, as soon as they identify, they have to manage the risk and even report it to the providers. And there are other entities in the value chain. The EU Act is very comprehensive, so it includes importers and distributors as well. So importers and distributors, basically, they must ensure compliance with similar requirements, but they're limited to their actions being importers, so importing all the systems, and distributors distributing in the EU market. So as an example, distributors could be AWS Marketplace or Google Cloud Marketplace. And how do we establish liability in the AI Act? So again, it's a case-by-case situation, but because they have created this framework, Uh, they have put several criteria. First, with the nature and extent of harm, authorities they evaluate the severity, scope, and ramifications of the harm caused by the chatbot, and encompassing both tangible damages and intangible damages. And it could even include emotional distress. And also contribution to the harm. Well, they have to check and assess um, specific actions or omission by different entities in the value chain, and they will specifically assess who contributed to which harm with a particular focus on adherence to the regulatory obligations, such as, again, risk management, transparency, and monitoring. And fulfillment of obligations, as we explained before, burden of proof is more on the enterprise side. So they have to provide evidence that they have a good risk assessment system. They have put it every safeguard process with all the tests, and also they are monitoring any emerging risk. So non-compliance means that they amplifies liability exposure. So EU Act, it's a share responsibility model. There's not only one entity, and the Act itself understands that concept and the industry. So therefore, it divided into different roles. Uh, so in, in terms of the South Korea AI Basic Act, it's the second AI regulation in the world. So after the EU's AI Act, and it has been enacted a few months ago in December, late December. So let's go through very similar but different. Again, you see already the definition. You talked about providers. South Korea chose the wording developer, but the same entity that develops and provides AI. And deployer, well, it's the entity that provides AI products or AI services using AI provided by the developer. So the law emphasizes accountability and responsibility for AI business operators through several key mechanisms, which is similar to the EUA Act. There are transparency obligations. So a big thing in Korea with deep fake and sex crime nowadays. So AI business operators must inform users if a product or service uses high impact AI or Gen AI. So Gen AI chatbots, for example. So for specifically Gen AI, they must indicate that the outputs are generated by AI. And if AI generated contents like audio, images, or videos are hard to distinguish from reality, they must clearly notify users. So this ensures users are aware when they are interacting with AI generated outputs. In terms of risk management, AI businesses that use large AI systems, there'll be a definition, but the definition is based on computing power. They must implement a risk management program that includes identifying, assessing, and mitigating AI-related risk throughout the AI lifecycle. And they also have to establish a system to monitor and respond to any AI-related safety accidents. And high-impact AI regulations, well, before providing AI products and services, AI business operators must assess whether their AI falls under the category of high-impact AI, and they may request confirmation from the Minister of Science and ICT. And if it is classified at the end as high-impact AI, well, they have to implement specific measures, including creating and operating a risk management plan, explaining the result of all these tests, also explaining the training data, implementing user protection measures, ensuring human management and supervision of the AI, and keeping records of safety and reliability measures. And again, similar to EU AI Act, doing an AI impact assessment is important. AI business operators must assess the impact of fundamental human rights before offering products or service using AI impact. So here, the South Korea government prohibits if you don't do this pre-assessment before. And as for domestic agent designation, of course, as we know, global leaders are not in South Korea. So AI business operators without a local Korean presence that meet certain criteria must appoint a domestic agent. So similar to importers' responsibility based on EU AI Act. So this agent acts as a point of contact for matters like submitting risk management results, confirming if AI is high impact, and supporting safety measures. So a bit similar but different and more simple compared to the EU's AI Act. For Canada, AI and Data Act, which I could say is almost bad with the government that is being dissolved, and we might have a new government soon. But initially, it aimed to regulate the development and use of AI systems, ensuring more ethical frameworks. So, determining responsibility for harm caused by an AI-based chatbot in Canada under AIDA, similar to EU, is a multifaceted issue. So, different stakeholders, a lot of participants involved in the value chain, and it initially separated, just like the other laws, into different roles. So the last version of the proposed amendment to AIDA clarified these responsibilities, as you can see. So for developers of generative AI systems, development includes methodology selection, collection, and processing of data sets, model building and testing, similar obligations to the EU AI Act. And for managers of Gen AI systems, well, it's about managing the operations, including putting a system into operation, controlling the parameters of the operation, and controlling access and monitoring its operation. So in an instance of harm based on AIDA, initially they wanted to create the commission. So the commission was supposed to be called Artificial Intelligence and Data Commission. And this commission investigate to determine if any party failed to fulfill its obligation under AIDA. So very similar again to the other two laws, leaving more responsibilities on the operators and developers. And liability would likely be shared among entities who failure to meet their obligations contributed to the harm. So the specific allocation of liability would depend on their circumstances. So case by case. So as we conclude our discussion today, let's imagine traveling forward in time to 2030. The AI chatbot you're interacting with to book your vacation suddenly gives you harmful financial advice that costs you thousands of dollars. So who do you sue? The AI directly, the company behind? Are you gonna find out who the developers are? So this isn't just a hypothetical scenario. It's a future that we need to be prepared. The rapid evolution of Gen AI has created what I call the accountability paradox. So on one side, we have increasingly sophisticated AI systems making more and more complex and in fact impactful decisions. And on the other side, we have traditional legal frameworks, regulatory frameworks, not up to speed to adapt to this new reality. So let's consider what we have learned today through three critical lenses. So first, the not yet principle. So when I emphasize that AI chatbots cannot be held accountable, liable, not yet, I'm pointing to an unknown future possibility. So as AI systems evolve, we might need to reconceptualize our entire understanding. Moral agency, legal personnel, we need to review, and as societies think about it and make a decision. Just as corporations evolve from simple business arrangements to legal entities, and some jurisdictions giving legal personnel to nature, AI systems may undergo similar transformation. And this raises profound questions. What level of consciousness or intelligence would qualify an AI for moral agency? That will be really all the researchers' role, your role to perform. And also, how would an AI system accumulate wealth? Let's say we give legal personnel the rights obligations. So if an AI system causes damages, how will it pay back? Will they be in insurance? Will they be able to like individually get insurance, or the companies deploying these AI systems will have to uh, buy the insurance product? Second, the web of accountability. So we have seen the accountability in AI systems is not a straight line. So it's very complicated, like a spider's web, multiple actors, and more, I feel like it'll be worse. So compared to this scenario that I gave, if a self-driving car crashes, we don't just look at the immediate software failure. So we have to examine the entire ecosystem, the sensor manufacturers, the algorithm developers, the training data, the car company, the city maintaining road signs, and even to go further to regulatory framework. So the means the city that allowed that car to be on the road. And the same principles will apply to AI chatbots. And third, the regulatory divide. Each jurisdiction is building their own regulatory, as you see. But so far, EU, South Korea, and Canada, it's still a build, the Canadian one. Very similar, maybe different mini definitions, but similar. But as you can see, big power nation is the US. And I think there were several bills, attempted bills to be enacted, and the federal level, at the state level. And currently, there's no one global um, definitions of all these AI systems already. So if we don't have a proposed unified definition already, it'll be really hard in terms of um, all these liabilities, responsibilities that we, as a whole society, wanted to establish altogether. So, for example, the EU's is very prescriptive. Canada initially tried to be in between US and EU. South Korea, I provided you just the obligation part, but if you check the whole legislation, 70% of the act actually talks about investing in infrastructure and investment. So it's only 30% of that act that talks about the obligation. So again, a different approach. Although again, similar concept affecting the consumers. So it'll be interesting to see how the new government in US will be willing to go against EU and trying to create less barrier, or continue with what the previous government has done. Although I know already what will happen, but it'll be interesting to follow. So personally, as technology evolves very fast, maybe too fast, I think there's a better approach that we could take. It's to have more principle-based regulatory framework instead of having a prescriptive one, and also as a society to watch out and to be ready and to try to understand, as any AI-related risk is not only impacting engineers, scholars, researchers, but anybody, restaurant waiters, managers, anybody on the street will be impacted. So it will be very important to follow and also try to understand what is behind all this. So remember this, question isn't whether AI system will become more powerful, they will. So the real question is whether our legal, ethical, and regulatory framework will evolve quickly enough to ensure that these systems remain beneficial tools rather than accountable agents of harm. So the Air Canada case we discussed today might seem relatively too simple to what I've shared with you, and the challenges that we'll face in the coming years. But it teaches an invaluable lesson. The time to establish clear accountability framework is now, before AI systems become too complex, and maybe it might be too late to regulate. Thank you for your attention. And now I think there's a session on Q&A.
Yes, thank you so much, Sun. This was a great presentation. Thank you for sharing all of this very interesting work. If anyone has any questions, feel free to ask in chat or raise your hand or unmute. And let's get started with that Q&A. I'll go ahead and start us off with the Q&A. So it was interesting when you mentioned the different acts that exist. You talked about these companies needing to do risk management. And it's kind of unclear to me how extensive that, or even like what that risk management would look like. Do you have any insights on what's currently being done?
Yes, risk management. So far, all these acts have provided high level responsibility, but as of today, I understand that a lot of companies are using risk management system such as the NIST AI risk management framework. So that's a very good example. And the ISO AI also, I forgot the exact name, but there's an ISO framework that a lot of companies are using. So those two are perfect examples, and even OECD recommends it. So I think, and I hope when the regulations, because the law is more high level, the regulations will provide more information. It's likely that it'll be more principle based, meaning that companies, you choose what you do, but you have to choose best industry standard risk management frameworks. So I don't think they'll dare the legislators, the governments define themselves. They're not experts. They will rely on the industry, academia, researchers to create those frameworks.
Yeah, that makes sense. Thank you for explaining that. Not seeing any other questions in chat so far. But again, feel free to raise your hand or ask in chat. All right, looks like no questions. Why don't we go ahead and end a little bit early? I want to thank you again, Sun. This was a fantastic talk. We really appreciate you coming and speaking to us.
Thank you. Thank you for having invited me.
Thank you.